Now we'll discuss about the characteristics of sovereignty. So, among the characteristics of sovereignty, the first one is absoluteness of the sovereign authority. Regarding absoluteness, it is a kind of juristic concept of the description of absoluteness of sovereignty is a kind of legal view. So here they described sovereign that there is no limit to the power or authority of the sovereign. So there is no power which is superior to the sovereign power. This way they establish the supremacy of the sovereignty, and that supremacy cannot be challenged. The next characteristic is the permanency or permanent quality of sovereignty. So in this context, they described that in a state, government may come and may go. There may be a death or temporary disposition of a particular bearer of the sovereign power or authority. But the very center of gravity lies with the sovereign authority. It only shifts from one part of a physical body to another. This is the view regarding the permanency or permanent characteristic of sovereignty. The next one, number 3, is universality. And regarding universality, they describe that commands of the sovereign are binding upon all persons and groups inside the state or in the society. So every command or every law made by the sovereign authority is absolutely binding, and it is universal as it is applicable to all persons and all groups those are existing in a society or state. Besides that, there is an extraterritorial power of the sovereign, but that extraterritorial power of the sovereignty of the diplomats or the envoys in a state is not a compulsion over the sovereign power or the sovereign authority of that state, because that sovereign authority or the sovereign is always at liberty to withdraw such privileges or immunities provided to a diplomat or to an envoy or to the diplomatic missionaries. The number 4 is inalienability of the sovereign authority. So here Professor Lieber give an example that as a tree cannot be alienated to its right to sprout, or a man cannot transfer his life and personality without self-destruction. So, sovereign cannot be separated or alienated like the right of a tree to sprout or a man to live with his right and personality, right to life and personality. So, also here regarding inalienability of the sovereign authority, the examples which are analyzed by the jurists that cessation of a part of state's territory is not alienable of sovereign power. So if there is a change of government or a transfer of sovereignty from one bearer to another, it also does not mean there is alienation of sovereign power or the supreme power of the state. The next character is indivisibility. So regarding this, there is the analysis of federal states or constitutions and the amending bodies, as in case of United States and Indian Constitution. The amending procedures of those constitutions are so difficult that it could not be easily amended any law that made by the sovereign authority by the parliament. So in this context, it is also explained that the very supreme power or authority of the state could not be divided in between the federal state and the federal units, neither it could be distributed among the legislature, executive and judiciary. In this context, Lasky criticized the very idea of indivisibility of sovereignty. According to him, the discovery of sovereignty in a federal state is practically an impossible adventure. So to him, it is very difficult if you take an attempt to discover that where exactly the location of sovereignty or supreme power in a federal state. The last characteristic of sovereignty is exclusiveness. Exclusive here means the state is alone possesses supreme power and legally competent to compel obedience of all the residents living in a state. It establishes the essential unity of state. So, here it is explained that every state alone possesses the supreme power to make law, and it is also legally competent to command or make laws, so it could compel all the subjects and groups living in a state for obedience. So this is all about the characteristics of sovereignty. Our next one is classification of sovereignty. Sovereignty could be classified as legal sovereignty and popular sovereignty, and lastly, political sovereignty. So, legal sovereignty is in terms of formal law, as for example, the king in parliament, in case of England. So, whenever there is a law passed or enacted by the parliament, and once it is being signed by the king, such command or law is considered as legal sovereignty. But Professor Dicey criticized it. He described that behind every legal sovereignty, there is another sovereignty to whom the legal sovereign must owe, and that is the political sovereign. And that political sovereign is nothing but the electorate. So the electorate of a state constitutes the political sovereignty, and so the legal sovereignty is always under or behind political sovereignty. The next one is popular sovereignty. Regarding popular sovereignty, we found in ancient Rome, Cicero, the ancient political philosopher, described that the very commonwealth is the people's affair. So the commonwealth means the entire people of Rome, they have the sovereign authority. So the political structure of Roman Empire was of absolute monarchy. Besides that, the very commonwealth that enjoyed the power to make law. The very concept of sovereignty in modern time was explained by Jean-Jacques Rousseau, the French philosopher, in his work The Social Contract, and also Thomas Jefferson, the English statesman. They also championed the very cause of popular sovereignty. But their very concept of popularity or popular sovereignty was better named by Professor Gilchrist, a political scientist, who named it as popular control, and it is better suits the idea of popular sovereignty according to Professor Gilchrist.